All right, perfect. All right, so we have a few students here. Can I see in the comments your names and if you have enrolled in the MP series or if you're internal students? Please just let me know in the comments. I'm keeping an eye on the comments as well. So just tell me your names and if you're enrolled in the Madhya Pradesh mock test series for prelims. Oh, hi Shakteja. So that's an internal student. Good evening. Very uh, heartwarming to see you here, and I'm very proud of all the hard work you're putting in and the consistency you're showing. And I have high hopes for you. So well done with the consistency with mocks, with rapid revision sessions and quizzes as well. So excellent work. And it also shows in your scores in the mocks. So for all of us here, I hope we are taking the mock test series mocks as they are uploaded. That is the same day that the mock is done. That allows us to track your progress. That allows us to give you a ranking of where you stand. And so in order to receive that ranking, as you keep asking for, ma'am, who scored the highest, who didn't, what was the ranking with respect to the scores of other students taking the mocks, we can only tell you that if you take it in time. If you take it after it has expired and then re-uploaded, we won't be able to give you the correct ranking. So all right, perfect, we'll be starting the quiz now. So this is your civil procedure code quiz for your Madhya Pradesh prelims, which are right about to happen. I hope you have taken the mock test and you're all set to go and ready to answer the questions correctly. So here we go. Here is the first question. In which scenario, sorry, in which scenario can a person sue another person in multiple courts for the same cause of action? So, in which of the following scenarios can a person sue one person in multiple courts for the same cause of action? So, is it when the person resides in one jurisdiction and carries on business in another jurisdiction? So he'll be suing them in the jurisdiction where they reside and also in the jurisdiction where the business is being carried on. Or is it when the person resides and carries on business in the same jurisdiction? Or is it when the person carries on business in one jurisdiction and personally works for gain in another jurisdiction? Or is it when the person is sued by multiple plaintiffs who reside in different jurisdictions? So, in this situation, the person is sued by multiple plaintiffs from different jurisdictions, and in this case, this person will be suing these multiple plaintiffs for the same cause of action in all the appropriate jurisdictions. So, which of these is it? We'll start a very quick timer, and anyone who can respond may respond in this while. And the correct answer is one, when the person resides in one jurisdiction and carries out business in another jurisdiction. This has been detailed in section 20 of the Civil Procedure Code. That is the correct answer. So, next question. A suit under the Civil Procedure Code is said to be impliedly barred under which of the following circumstances? So, when is a suit impliedly barred per the CPC? Is it barred when it is, barred by general principle of law? Is it for that purpose impliedly barred under CPC? Or is it considered to be impliedly barred when it is barred on the ground of public policy? Or are both options 1 and 2 correct? Or is neither 1 nor 2 correct? All right. Excellent. Chetan has beat the timer. He thinks option 1 is correct. That is being barred by general principle of law. Shaktija, what do you think? The timer has ended. I will have to reveal the answer now. The correct answer is both 1 and 2. We have to go to, Shaktija is correct, both 1 and 2. We have to go to section 9 of the CPC, which talks about what is referred to as being impliedly barred, right? So, being barred by public policy because certain suits are of civil nature, and in them there are certain bars due to the nature of public policy, right? And then certain suits are barred by general principles of law. Both are consistent and included in the broad ambit of being impliedly barred. So both 1 and 2 are correct and understood to be impliedly barred under CPC. Next question. In which one of the following cases is second preliminary decree granted? Is a second preliminary decree granted in a preemption suit, in a suit of partnership, in a suit of partition, or is it granted in all of the above suits? I'll give you just a few moments before I start the timer. Where is a second preliminary decree granted? A second preliminary decree is not really granted in many cases. So, which of these will make the exception? Vijaydeep thinks all, Ayushi thinks all. All right, perfect. And your correct answer is, of course, all of the above. We refer to the judgment of Alagamal versus Gopal in 1967, where the Supreme Court stated that upheld a second preliminary decree in all cases in partition suits, right? Uh, and by thus, all of the above were considered to be correct, and also in partition suits, they were held to be um, correct in law to be granted. So, apart from that, partnership and preemption suit are also allowed, and the passing of second preliminary decrees in partition suits was found good in law by the Supreme Court's 1967 judgment. Next, we move on to the question. The report of commissioner with respect to trial code proceeding CPC is of what nature? So this explores the retrospective prospective effect of the law of CPC. So if there is a report of commissioner with respect to a trial code which preceded which is happening under CPC, what is the nature of such a trial court and the nature of such a report that spans it? Is the report exhaustive? Is the report conclusive? Can we say that the report is not conclusive, or are we to say that the report is not exhaustive? All right, I'll start the timer. Answers coming in. Excellent. So most of us here think it is 4. Shaktija thinks 3. Shaktija is correct. So what is correctly determinable here is that such a report will be not conclusive and not exhaustive. Such a report will be not conclusive. We go to Order 26 Rule 9, and it states that such a report of a commissioner, it will be only a piece of evidence and not binding on the trial court. So it's not conclusive. It's not conclusive in matter of defining the final right. So it's only a piece of evidence, not binding on the trial court. So Shaktija is right. Well done. The duty to frame proper issues rests primarily on whom amongst the following? So, who is tasked with preparing proper issues in front of the court? Is it the parties to the case? Is it just the pleader of the parties, the pleaders who appear before the court? Is it the court itself? Or is it just the plaintiff who appears before the court that he has to frame proper issues? So, I'll start your timer. This is quite a straightforward question. We should get an answer right ahead. Excellent. It is the court. It is the duty of the court to frame proper issues. The issues will be presented and brought to the court by the pleaders, by the parties, whether it's the plaintiff, whoever, but the framing of the issues is done by the court itself. The judge understands what is before it in terms of the facts of the matter, and then he frames the issues. So, if we at many instances see that a lower court is framing the issues improperly, and then the other court is stepping in, whether it goes up for appeal or whether the case is dismissed and then goes to another court for revision, then goes to the court for revision, or whatever it may be, it is examined whether the previous court framed the issues properly or not, and it is within the correct working of the court to frame issues correctly. Next question. During proceeding for execution of a decree, if a question arises as to whether any person is or is not the representative of a party, such question shall be determined by. So, if a question arises while there is a proceeding for the execution of a decree, whether a person is a representative of the party or not, what is done? Who determines this question? Is it that the court which passed the decree itself will examine this question? Is it that the court that is executing the decree will determine this question? Will both courts be allowed to determine this question? Or will we then create a separate suit to determine this question? I'll start the timer. Something it's both one and two, something it's the court executing the decree, something a separate suit is required. All right, let's see more answers while the timer ends. The correct answer is the court executing the decree. So Vijaydeep is correct. We go to section 47(1) of CPC, and it states that the court executing the decree will deal with these questions, right? So if there are questions of the nature such as between the parties which relate to the execution, discharge, or satisfaction of the decree itself, the court executing it will be the court tasked with determining these questions. It will not be done by a separate suit. The court executing will be determining these questions. Question number 7 is the court cannot order execution of a decree as per section 51 of CPC in which of the following ways. So there are many ways in which the court can order the execution of a decree to be made, but the court cannot. Let's pay clear attention to what the question is asking. So a negatory question. The court cannot order execution of decree in which of the following ways? Is it by attachment and sale of property? Is it by a decree for restitution, in a decree of restitution of conjugal rights, by sending the person's husband or the person's wife, as the case may be, to the civil prison? Is it by appointing a receiver, or is it by all of the above? All right, we are quite confident on the answer here. Excellent, everyone answering before the timer. This is the spirit we want in the examinations. Let's keep that up. And we are all correct. If we were to be very haphazard in reading our questions, we would not have seen the cannot portion and we would have answered the question wrong. But we have to be very mindful on what the question was asking us. It asked us how a court cannot order execution, and option 2 is correct for that as we go to section 51(1) of the CPC. Next question. Who has the authority to make a panel of commissioners to record evidence? Who makes a panel of commissioners under CPC for the purpose of recording evidence? Is it the High Court? Is it the state government? Is it the district judge? Or can it be either High Court or state government? I will start the timer. I think Jasmine thinks it's state government. Vijaydeep thinks it's either state government or the High Court. It is actually the district judge. We have to go to Order 18, Rule 5 for this. So the district judge has to be tasked with preparing the panel of commissioners for, recording evidence under Rule 5 of Order 18. Next question. Which of the following is or are the fundamental rules of pleading as set forth under Order 6, Rule 2 of CPC? So, fundamental rules of pleading as mentioned under Order 6, Rule 2, which is one of those fundamental rules of pleading. Is it that every pleading must state facts and not law only? Is it must state material facts only? That is, every pleading must state material facts only. Every pleading must state such facts in a concise form only, or is it all of the above? All right, Most of us think it's all of the above. I've started the timer. Let's see what the correct answer is. And it is all of the above. We go to Order 6, Rule 2, and it tells us how pleading should look like, what it should contain, and all of the above, as we saw, are contained in Order 6, Rule 2. Question 10. On which of the following grounds will a plaint be rejected? So we should again know this. We are preparing for judicial services examinations. As judges of tomorrow, we should know what are the grounds for rejecting a plaint. So when will you reject a plaint? Will you reject a plaint where the suit appears from the statement in the plaint to be barred by any law? Will you reject a plaint where the relief claimed is overvalued and the plaintiff, on being required by the court to correct the valuation within a time to be fixed, fails to do so? Will you reject a plaint where it has not been presented by an advocate? Or will you reject a plaint in all of the above situations? Okay, so Judge Subrat will reject a plaint where the suit appears from the statement in the plaint to be barred by any law. What about the rest of us? Okay, Jasmine will reject a plaint in all of these circumstances. Chetan will also follow Judge Subrat's precedent. So let's see who is right in law here. What are the rest of the judges doing? Dormant. All right, so the precedent set by Subrat was absolutely correct. Order 7, Rule 11 provides the grounds for rejection of plaints. And see, barring of law will be a manifest defect in the plaint and will subject it to absolute rejection right there and then. So, option 1 was correct. Next question. Can a civil court examine a party at first hearing? Can a civil court examine a party at first hearing? What is the stage of examination of a party by the civil court? Is the correct answer no? Is it yes? Is it the court cannot examine a party till evidence has been recorded? Or is it the court cannot record admissions and denials? All right, I think we have very vehement responses on this as well. I'll start the timer right ahead. So Jasmine thinks yes, the court can examine a party at first hearing, and that is correct. Order 10 does allow for it. At the first hearing, the court is allowed to ascertain from each party or the pleaders about the allegations of facts, etc., and all of that stuff, and thus it is allowed to make the examination of the parties. Interrogations shall be answered as provided under Order 11, Rule 8 of the Civil Procedure in which of the following ways? Will interrogations be answered on a simple application? Will we require an affidavit to do so? Will it be done by filing the documents? Or do we require all of the above to answer interrogatories? All right, Jasmine thinks affidavits. I'm beginning the timer. Jasmine, excellent job. Very on spot and very handsy with the answers. Excellent speed you've got there. Let's keep it up in the examinations. And you're also correct. Well done. So Shaktija, not option number 4, option number 2, that is on affidavit. We didn't require all of those things. We just require it to be on affidavit. Why? Because Rule 8, Order 11 provides for that. So interrogatories are to be answered by affidavit and also to be filed within 10 days or within such a time that the court may allow. So it's open-ended there, but generally 10 days. Which of the following is true with regard to the affidavit under the CPC as a general rule? So this is a general rule. Generally, what do we follow as a rule of thumb? Any exceptions are not asked here, just a general rule. Is it that affidavits can be confined only to statements of knowledge? Is it that affidavits can be confined only to statements of beliefs? Is it that affidavits cannot be confined to statements of belief only on interlocutory applications? Or is it none of the above? All right, Vijaydeep thinks that the general rule is that affidavits can be confined only to statements of knowledge. Let's see. Okay, I see we are all following precedents here. Excellent, and we are correct. Yes, Vijaydeep, it's one only. Affidavits can be confined only to statements of knowledge. That is, again, the general rule. We have to go to Rule 3, Order 19 for this. Question number 14. Order 20, Rule 1-2 of the CPC requires that a copy of the judgment be made accessible to the parties, but when? When is it to be done? Does it require that it be done immediately after the pronouncement of the judgment, or after 7 days from the pronouncement of the judgment, or after 14 days from the pronouncement of the judgment, or after 21 days after the pronouncement of the judgment? I'm starting the timer. All of us think it is immediately after the pronouncement of the judgment. Let's see, and we are correct. We go to Rule 6B of Order 20 for this. That states that the copy shall be made available to the parties immediately after the pronouncement of the judgment. Question 15. The consequences of a judgment debtor failing to submit an affidavit of assets in accordance with Order 21, Rule 41.2 of the CPC includes. So, what are the consequences? Now we are looking at the penalties appended. Is it civil imprisonment up to 3 months for the judgment debtor? Is it civil imprisonment up to 6 months for the judgment debtor, civil imprisonment up to 9 months for the judgment debtor, or imposition of fine on the judgment debtor of the amount involved? So, if the judgment debtor fails to submit an affidavit of his assets in accordance with Order 21, Rule 41, what is the penalty he will incur? I will start the timer now. Any responses, any guesses you might have? You can be wrong here. We are free to be wrong here, just not in the actual prelims, please. It is civil imprisonment up to 3 months for the judgment debtor. We have to go to Order 21, Rule 41.2. It states that where a decree for the payment of money has remained unsatisfied for a period of 30 days, the court may, on the application of the decree holder and without prejudice to its powers under sub-rule 1 of this order, by order require the judgment debtor, or wherever the judgment debtor is a corporation, any officer thereof, to make an affidavit stating the particulars of the assets of the judgment debtor. So, next question. When the plaintiff is present and the defendant, after being, again, so these are basically not a lot of complex question asking in the MP levels, but I have still included a few situation based questions. This is by far just very direct. It won't present an actual fictitious situation, but still asks you to step out of the provision bare act based language and examine the provision just a little bit. So, when the plaintiff is present and the defendant, after being served, fails to submit a written statement, what does the court do? Does the court still pronounce the judgment under Order 8, Rule 10 of CPC? Is it that the court may require either the plaintiff to prove the case by leading evidence, or the court will pronounce its judgment against the defendant himself because he has not submitted a written statement, depending upon the nature of the case? Or is it that the court necessarily requires the plaintiff to prove his case by leading evidence? Or is it that the court will require that there is direct personal appearance of the defendant nonetheless? So I will start the timer. Let's see who is correct. Vijaydeep and Jasmine answering option 2. Ayushi Dubey thinks it's option 1. It is 2 indeed. So what the court does is it either requires the plaintiff to prove by leading evidence the case, because that's the only evidence available. The defendant has not signed and not written in the written statement, or the court will examine everything and pronounce the judgment against the defendant. That will, of course, be an ex parte judgment. So this is per Order 8, Rule 10. Now, question number 17. A subsequent suit based on the same cause of action is allowed under which of the following orders and rules? We know cases of same causes of action, same parties, and barred, right? They're not allowed by procedure of law, by a policy of law, so that there is no redundancy, there is no overburdening of courts. But a subsequent case, which is done on the same cause of action, will be allowed, but it is done so in which of the following orders and rules? Is it where a suit is dismissed under Order 9, Rule 8? Is it where a suit is dismissed under Order 9, Rule 3? Is it where the suit abates under Order 22, Rule 3.2? Or is it where the plaintiff abandons the suit himself as under Order 23, Rule 1.1? So I will begin the timer and you can leave your guesses in the comments. So where is a subsequent suit based on the same cause of action allowed? Shaktija thinks it's 3, that is Order 22, Rule 3.2. It is actually Order 9's Rule 3, where the suit is dismissed under that. So the court is allowed to take the you're allowed to take a subsequent case on the same cause of action. Question number 18. A owes B rupees 100 and is willing to pay him that sum without a suit. Now, this was the situation based fictitious case I was talking about. A situation based case. A is owing B rupees 100 and is also willing to pay him the 100 back without any suit being involved. Now, B claims rupees 150 but sues A for that amount, even though A was willing to pay it back without a suit. On the plaint being filed, A pays 100 into the court and disputes his liability to pay the remaining 50. B now accepts the 100 in full satisfaction of his claim, so basically foregoes the 50 rupees. What will the court do? Will the court order B to pay the cost that A incurred in this case, which he didn't want to be part of to begin with? Or is the court not allowed to order B to make such a make such a payment from B to A of the costs? Or can the court go to the extent of providing B punishment? Or is it both 1 and 3? There's a typo, this should be 1 and 3. What do we think? I'm beginning the timer. See, there is a general, just a directory measure. The court should order B to pay A's costs. We go to order 24 for this, rule 4.2, and this is straight out of the illustration to rule 4.2. It is illustration C, and where the court is looking at such a situation where the person was willing to pay that amount and then paid that amount completely. In this situation, the court is empowered to order B to pay the costs that A incurred in this particular case, to go to the court, to employ a pleader, and all of those technicalities. That is, the court is allowed to have B pay that back to A. Next question, again a situation based question. A sues B on a bill of exchange. B alleges that A has wrongfully neglected to insure B's goods and is liable to him in compensation, which he then claims to set off. Decide this case. Again, I'll read it. A is suing B on a bill of exchange. B is alleging that A has wrongfully neglected to insure B's goods and is liable to him in compensation, which he claims to set off. Now decide the case. The amount that is not being ascertained can be set off. The amount that is being ascertained cannot be set off. The amount that is not being ascertained cannot be set off. Or are none of the above correct? So this is a bit of a brain tester, not a teaser, just a brain tester. Let's see where we go with this. Let me give you a bit of time to go through it again if you need to, and then I'll start the timer. All right, we have the first answer, and I'll start the timer now. Vijay has beat you all to it. Vijay thinks it is that the amount not being ascertained can be set off. So the amount not being ascertained, Vijay, cannot be set off. So you slipped up here. Option 1 was can be set off, whereas order 8, rule 6 in its illustration provides this exact situation, and the amount that is not being ascertained, it cannot be set off in the situation. You chose can be set off, it cannot be set off. Next question, that is question number 20. Question number 20 is, in a suit instituted against a public officer in respect of an act done in his official capacity, under what circumstances can the defendant be exempted from personal appearances? Is it where the defendant is unable to afford travel expenses? Is it where the defendant is a high-ranking government official? Is it where the defendant's absence would be detrimental to public service? Or is it if the defendant requests exemption in writing? Okay, Ayushi has answered the defendant's absence would be detrimental to public service. I'm beginning your timer. Let's see. Ayushi is correct. We go to section 81B of CPC. Here, the court will be, if the court is satisfied that the defendant cannot absent himself without causing a detriment to the public service, such an absence is exempted. Question number 21. According to section 49 of CPC, what is the liability of a transferee of a decree? So, a transferee of a decree. Is it that the transferee is not liable for any equities enforced against the original decree holder? Is it that the transferee holds the decree without any liabilities? Is it that the transferee holds the decree subject to the equities enforced against the original decree holder? Or is it that the liability of the transferee is determined by the court executing the decree itself? Which of these is correct with respect to the liability of a transferee of a decree as under section 49 of CPC? I'll give you a bit of time to go through the options available so that you read it well. Vijay, take special care, read it very well. Words like not, can, these slip up on you and you make errors which cost you marks. All right, we have a few responses already. I hope you've read all the options and you're contemplating your responses. I'll begin the timer now. All right, excellent. Well done with reading purposefully. 3 is indeed correct. Well done, Vijay. Well done, Ayushi. The transferee holds the decree subject to the equities enforced against the original decree holder. And this is via section 49 as mentioned in the question. Section 49 does state for it. Question 22. Which of the following deals with power to pronounce judgment written by judge's predecessor in the CPC as provided in CPC? A judge's predecessor wrote a judgment, and now which provision gives another judge to pronounce such a judgment? Is it Order 11 Rule 8, Order 19 Rule 2, Order 14 Rule 3, or Order 20 Rule 2? We do discuss this particular provision a fair bit because it's a very peculiar provision. You can pronounce a judgment that was written by your predecessor. You must know this. I'm starting the timer. Shaktija thinks it's Order 20 Rule 2. Well done, Shaktija. Let's increase the speed. You're correct. Look at that. Excellent work. So Order 20 Rule 2 provides for this. We are trying to inculcate a higher response time with the aid of the timer and everything. So let's make good use of it. Let's try to race through the questions. And it's okay if you're wrong, you get time to correct yourself here. Just as long as you're not answering wrong in the actual prelims, we are here to train you. The Amendment Act of 1976 for Section 82 of CPC did away with which of the following? So, did it do away with the application of execution to certain orders and awards? Did it do away with the requirement of a report by the court to the state government if the decree has not been satisfied within the time set out therein? Did it do away with the suspension of execution for a further period of 3 months after the date of report being sent from the court to the state government? Or did it do away with both options 2 and 4? All right, so this is about the Amendment Act of 1976. It made some peculiar changes. What did it do away with? Which of the following did it do away with? It helps to know a bit of the history about how CPC's provisions changed with time. I'm starting the timer. Let's see what it did away with. The Amendment Act of 1976. It did away with both 2 and 3. So, as we can see, Section 82 was involved and it did away with the cumbersomeness and the time consuming procedure. How did it do it? It replaced the word report for decree, right? And it made certain changes because now the execution shall not be issued on any such decree unless it remains unsatisfied for a period of 3 months computed from the date of such decree, whereas it said as against report before the Amendment Act. Yes, it added time expedition. It wanted to expedite the time taken in solving the issue. Shaktaja, that's a good remark you made there. Question 24 next. What happens if a defendant fails to disclose documents within the written statement or a counterclaim? What happens? Again, we are talking about the repercussions of various faults and failures. Does the defendant lose the right to rely on those documents during the proceedings? Does the court grant an extension to the defendant for disclosing the documents? Is it that the plaintiff can now file an objection and request the court to compel the defendant to disclose the documents? Or is it that the defendant can disclose the documents later during the trial phase? So, what happens? Again, this is part and parcel of the proceedings, general proceedings before the civil court, and something you should be prepared as lawyers and judges appearing in the judiciary examinations. A normal part of ups and downs that happen in a case. Ayushi thinks that the plaintiff is now allowed to file an objection and have the court compel the defendant to disclose such documents. Let's see. So, what happens is that the defendant loses his right to rely on those documents during the proceedings, because if he had them, he could have disclosed them in the beginning only, and that would have given him um, a correct position in law to rely on those. He cannot just pull them in the middle of the proceedings. So, Order 11 states that the defendant will not be allowed to rely on documents that he had with him to begin with, but he did not disclose them in the counterclaim or the written statement. Again, there are certain exceptions to it. There might be situations where this is allowed. They are mentioned in sub rule number 10 of the order. Now, question 25. When can the court call upon a party to admit any document, even without a notice to admit being given? So, even without such a notice being given, can the court call upon a party to admit any document? Is it only after the completion of pleadings? Is it only after the production of evidence? Is it at any stage of the suit at the court's discretion? Or is it only when requested by the plaintiff? The correct answer is at any stage of the suit at the court's discretion. So of Rule 3A of Order 12 provides that the court has the power to call upon any party to admit any document at any stage of the proceeding, even if there is no such notice to admit documents, as in as keeping in with rule number 2. So the court will record whether the party admits, refuses, or neglects to admit such documents. So that is that provision over there. Next question is under Order 12, if admissions of, again, a question on Order 12. Under Order 12, if admissions of fact have been made, the court may give judgment in which of the following cases? Only after the determination of all other questions, without waiting for the determination of any other questions, only if the parties agree to do it, or only if the admissions are made orally. The correct answer is option number 2, without waiting for the determination of any other question. That is correct. We go to rule 6.1 for this. Just a moment. Please give me a moment. I'll load the next question. Please excuse me for just a moment. Sorry, guys, I hope you've given answers, and we think it's three, so it's both movable and immovable property. Yes, that is correct. Section 61 does specify that lands, houses, buildings, goods, that is both movable and immovable properties belonging to the judgment debtor, will be liable to attachment and sale and execution of a decree. So anything that the judgment debtor owns or has a disposing power over, irrespective of whether it is movable or immovable, goes into the attachment. Next question. In a suit against any other state government, who can receive the written notice before instituting the suit? Is it the governor of the respective state? Is it the CM of the respective state? Is it the secretary to the respective state government? Or the district collector to the respective district? So, which is the correct authority here who can receive it? Answer 3 is correct. The secretary to the respective state government, as provided in section 81C. When can the court amend or strike out issues in a suit? Is it to be done at any time before the filing of the written statement, any time before the passing of a decree, any time before the settlement of issues, or any time during the trial proceedings? It is any time before the passing of decree. So not 4, but option number 2. We go to Rule 5.1 of Order 14 for this, allowing the court to amend the issues or frame additional issues, but it must be done at any time before passing the decree. And apart from this, the court can also strike out issues that existed up until that point. So it can amend, frame newer ones, or strike out ones that exist already. If there are multiple defendants in a suit and one of them is not at issue with the plaintiff, what can the court do? Does the court adjourn the suit for further evidence? Does the court pronounce judgment for or against the defendant that is not at an issue with the plaintiff? Does the court dismiss the suit against all the defendants, or does the court frame additional issues for clarification? I will begin the timer now. It is 2, pronouncing the judgment for or against the defendant who is not at issue. Rule 2 of Order 15 provides for this. It kind of terminates the situation with the defendant who is not at issue and then proceeds the rest of the case with the defendants at issue with the plaintiff. Now, question number 31, legal representative as under section 211 of CPC, who does this refer to? The term refers to, is it to a person who in law represents the estate of a deceased person, any person who intermeddles with the estate of the deceased, any person of a representative character of the person on whom the estate devolves on the death of the party that is suing or is being sued, or is it all of the above? All right, most of us think it's all of the above. So, all of the above under the umbrella of being called a legal representative. And that is correct. Section 211 does describe legal representative as any of the options available there. Where can a plaintiff apply for a temporary injunction to restrain the defendant from committing a breach of contract or injury? So, if you want to, as a plaintiff, prevent the defendant from committing a breach of contract or injury, where can you apply for a temporary injunction? When can you apply for a temporary injunction? Is it only after the judgment is given? Is it before the commencement of the suit itself? Is it at any time after the commencement of the suit? Or is it only when compensation is claimed in the suit? All right, so most students think it's 4. Chetan thinks at any time after the commencement of the suit. Let's see. The correct answer is 3. Yes, Chetan, Aditya, Ayushi, Shakti, all right. Rule 1 of Order 39 does provide for it. Under Section 15 of CPC, every suit shall be instituted in a very simple question. We should all know the answer to this: in district court or the competent court of lowest grade, the court of higher grade, or all of the above. I will start the timer. Divya is answering option B. That is correct. Section 15 states that the courts should suit should be instituted. You should always try and aim to institute a suit in the lowest grade court competent to try such a suit. After the attachment of the property, private alienation of the same is it void ab initio? Is it voidable at the option of decree holder? Is it voidable at the option of judgment debtor? Or is it void as against all claims enforceable under the attachment? All right, let's see guesses on this question now. So, this is about after attachment of property. What is true of private alienation of the same property that has been attached? All right, we are getting answers that it will be void ab initio. Come on, can the rest of us answer as well? All right, see. The correct position as per section 64 of CPC is that uh, such an action with respect to such attached property that will be void as against all the claims enforceable under the attachment. So not just mechanically, we don't have to click the option that says void ab initio. It will be void as against all claims enforceable under the attachment. This is the correct position set out by section 64 of CPC. Where property is under attachment in execution of decrees of more courts than one, which court shall determine any claim on the property or any objection to the attachment? Is it that the court of highest grade will be allowed to do it? Or where there is no difference in grade between the multiple courts where the case is, the court under whose decree the property was first attached, that property will be allowed to determine the claims or objections. Is it only A or is it either A or B? All right, so Subrat is saying that where there is no difference in the grade of the courts, the court who first attached the property takes precedence here. Shaktija as well. I'll start the timer. What about the rest of us? What do we think? Chetan thinks both can do so. That is correct. Chetan is right, either A or B. So where the property's execution, the property's attachment and the decree execution of such decrees is with multiple courts. So you know either it will be the court of highest order, or where there is no difference between the court's orders, the court that decreed the attachment that attached the property first. So either A or B, you either go the route of whichever court is higher. Where the court's rate grades are equal, you go to whichever court made the attachment first. So we have to follow either A or B. Chetan is right. Again, guys, why are we answering two? Let me go back to the option so that you gain a bit of clarity. The court of highest grade, yes, but there can also be courts with the same grade that are attaching the property. In that situation, we go to the court that did the attachment first. So let's be very mindful of the provisions. Well done, Chetan, for not getting tricked by this. This is just the same provision. It was clumped and we broke it up into two different options to confuse you. So don't just grab the shiny option first, read all of them. Where immovable property forms one estate or tenure situated within the local limits of the jurisdiction of two or more courts, then the court can sell only that part which is in its jurisdiction, or any one of the court may sell the entire estate, or no court can sell any part of the estate, or the court can sell the entire estate within whose jurisdiction majority portion of the property is situated. What happens? Again, quite a practical problem to have as judges of tomorrow. What is the correct legal position on this? Which court sells what portion? Let me see some answers. Come on. I'll start the timer now. Okay, so Shaktija thinks it's an equitable answer. Whichever court has however much land it has jurisdiction over, it can. All right. The correct legal position here is that any one of such court may sell the entire estate or tenure or may attach it. This is per Order 21, Rule 3, right? So if immovable property forms one estate or tenure which is situated within the local limits of two or more courts, any one of them may sell or attach the entire estate or tenure. The power enjoyed by the court to fulfill needs of justice in absence of a specific provision of CPC is labeled as which of the following within CPC itself. So, a power which the court has to fulfill the needs of justice where there is no specific provision, where CPC otherwise is silent on such a situation. What is it labeled? What nature of a power is that? Is that a discretionary power? Do we call it the inherent power of the court? Do we call it the delegated power of the court? Or do we call it the mandatory power of the court? We must be very clear about all the dynamics of the powers that are vested in civil courts. So, what form of power is it where the court is fulfilling the needs of justice, where the rest of CPC is silent about it? All right, so Shaktija thinks it's inherent, or Shaktija thinks it's discretionary, and Vijay and Chetan think it's inherent. It is inherent. So we go through section 151 for this because it saves the inherent powers of the court and states that nothing in this code shall be deemed to limit or otherwise affect the inherent power of the court. So it states that this power is already within the court to make orders as may be necessary for achieving ends of justice and preventing the abuse of the process of the court. So that is the inherent power of the court. Yes, Shakteja, that is option number 2. So mesne profits of property means profits received by a person having which of the following? Is it profits that are received by a person who is in unlawful possession of property, or a person in wrongful possession of property, or a person in lawful possession of property, or a person in effective possession of property? Okay, Chetan and Subrat. Chetan. Either of Chetan or Subrat is confused. It is Chetan because it's not unlawful, but it is wrongful possession of property. If you are in unlawful possession of property, you are pretty much not entitled to get anything. In fact, you'll be brought to the civil court. It is wrongful possession of property. So if you're in wrongful possession of property, so if with ordinary diligence you have received something, that is called mesne profit. Next question. A caveat lodged under Section 148A of CPC will remain in force from the date of its being lodged till how many days? Till 30 days, till 60 days, till 90 days, or is it till 45 days? And the correct answer is 90 days as per again 148A. So the correct period of expiry, as in subsection 5, is 90 days from the date on which it was lodged. Who among the following is not entitled to exemption from personal appearance in the courts under proceedings of the CPC? So, who is not entitled from exemption? Again, we have to read the question very purposefully. Is it the President of India? Is it the chairman of the state legislative councils? Is it the collector? Or is it the ministers of states? All right, I'll start the timer. So well done. We have read it correctly. It is the collector. All the others have exemptions with a long list of several other honorary members who have exemptions. Shaktijan, no, the question asked us who is not exempted. Who is not exempted from absence, right? Sorry, not exempted from presence. So, who is not allowed to be absent? So, the collector, there is no such provision. The collector is not given such an exemption. However, the president, the chairman, the ministers of states are. This is 133 that provides for the list of people who are exempted from personally appearing in the court. What will happen if neither party appears when a case in a civil court is called for hearing? The court may return the plaint, the court may pass the decree in favor of the plaintiff, the court may make an order that the suit may be dismissed, or the court may reject the plaint outright. So, what is the correct thing that will happen if neither party appears when a court is calling for the parties to be appearing and when the court is hearing the case? I'll start the timer. The Divya and several others have answered. That is right. Option 3 is correct. The court may make an order that the suit be dismissed because neither party appeared. What is the court to do? The court will dismiss the entire suit. This is Order 9, Rule 3. Which of the following is a ground to set aside an ex parte order? On which of the following grounds will you tomorrow, as judges, set aside an ex parte order of a previous court? Where the summons were not duly served, where the order was prevented, where the person was prevented by any sufficient cause from appearance, the person who is ex parte, the person who has not appeared, he was prevented by sufficient cause from appearance, and still the previous court made an ex parte order. Will you then set aside the ex parte order? Is only A correct, or both A and B are correct? Aditya thinks option 4. I'm starting the timer. Subrat also thinks option 4. Shaktish also thinks option 4. That is correct. Order 19, Rule 13 provides, again, we discussed this before, the provisions for setting aside decree ex parte against a defendant. In which circumstance will it be allowed? Which section of CPC grants exemption to members of state legislatures from arrest and detention under civil process? So which section gives this exemption and special protection? Is it section 80, section 134, section 135A, or is it section 132? I have started the timer. Let's see some answers, attempts at answers, please. The correct answer is 135A. 135A exempts members of legislative bodies from arrest and detention under civil service, like we just saw. Exemptions from appearance. Similarly, there is exemption from arrest and detention under civil process. All right, reasoning and statement-based question now. I'll give you a bit of time to read it, but I'll recite it once. The reasoning is the costs, there are two statements, R and S. Let's call them R and S. R is that the costs ordered to be paid under subsection 35B1 of CPC, 35B1 of CPC, shall not, if paid, be included in the costs awarded in the decree passed in the suit. So that is the orders that is the amount that is paid already. It should not be included in the order going forward. It should not be included in the cost going forward in the decree. S, where separate defenses have been raised by the defendant or groups of defendants, payment of such costs shall be a condition precedent. Now, which of the following statements is true? Is R true? Is only S true? Are both true? Are both wrong? I'll give you a bit of time to read them on your own pace. You just have to determine which is correct. It is possible that both may be correct. It is possible that both may be incorrect. All right, I'll start the timer now. Both R and S are correct. We go to 35B. It states, if we go through it, it states that both R and S, both statements are included within it. Both are correct. The definition of signed as under section 220 of CPC includes which of the following? Does stamped mean signed? Does received mean signed? Does offered mean signed? Or is it that none of the above are included in the definition signed? Quite an easy question to answer. I'll start the timer. It is stamped. So signed includes the word stamped. If a judgment debtor is committed to the civil prison in execution of a decree, the court shall fix for his subsistence such monthly allowance as he may be entitled to, according to the scales fixed under which section of CPC? Is it under section 43 of CPC, section 78 of CPC, section 57 of CPC, or either Section 43 or 78 of CPC. All right, Vijay and Chetan think it's 57. Aditya, Shaktija, 57 Chetan. 57 Chetan is correct. Vijay is correct. So Section 57 does fix those scales. A foreign state may sue in which of the following courts? May it sue in a superior court, in any competent court, in the apex court only, or in a lower court? Where can a foreign state sue? Again, a very easy question, often appears in papers. So the correct stance is that the foreign state may sue in any competent court, and Section 84 of CPC provides this. Any competent court. When a decree is for the payment of money, the court may, on the blank application of the decree holder at the time of passing the decree, order immediate execution. So, is it that the court does it on written application, oral application, implied application, or none of the above? Starting the timer. It's oral, right? So, if the decree is not for the payment of money, if the decree is for the payment of money made, the court, on oral application of decree holder at the time of passing the decree, is allowed to order immediate execution. What does it do thereby? It arrests the judgment debtor prior to the preparation of a warrant if the judgment debtor is within the precincts of the court itself. Which section of CPC deals with appeals in Supreme Court? Again, a question you might be able to answer very quickly. Section 104, Section 105, Section 106, or Section 109. Appeals in Supreme Court. It is 109. It deals with appeals before the Supreme Court. Question 50. Which section of CPC deals with suits for compensation for wrongs to persons or movables? Is it Section 17, Section 18, Section 19, or Section number 20? Suits for compensation for wrongs to persons or movables. It is Section 19. That is the title of Section number 19. Question 51. In suits by or against a corporation, any pleading may be signed and verified on behalf of the corporation by whom? By the secretary, by the director, by the principal officer, or all of the above. What is correct here? That's correct. Option 4, Aditya. Shaktija, that's correct. All of the above. Order 29 states that it allows any of them to be making this action. So all of the above are correct. Section 98 of CPC does not affect which of the following? Letter to administration of any high court, letter to patent of any district court, letter to patent of any high court, or letter to administration of any district court. Letter to patent of any high court is the correct answer. Section 98(3) provides for it, stating that nothing in this section shall be deemed to alter or otherwise affect any provisions of the letter to patent of any high court. Under Order 21 of CPC, a decree for restitution of conjugal rights can be executed by attachment of property, civil imprisonment, either attachment of property or civil imprisonment, or attachment of property and civil imprisonment both. So let's see some answers. I'll begin the timer shortly. All right. Chetan thinks his attachment of property is correct. Shaktija as well. And that is right. Order 21, Rule 32 does provide that for restitution of conjugal rights, attachment of property is how the court makes specific performance compelled. In a few questions, we'll take just a brief break and we can talk about the progress so far and how you're doing with the MP series. So just hold on a few more questions. I know it's a bit draining to go through so much mental activity. Under Order 41, Rule 23, when the court from whose decree an appeal has been preferred has disposed of the suit upon a preliminary point and the decree is reversed on appeal, the appellate court may dismiss the suit or remand the case for reconsideration to the lower court or stay the suit or do any of the above or all of the above. So, the court from whose decree an appeal has been preferred is disposing the suit on a preliminary point, and then the decree is reversed on appeal. What is the appellate court to do? Dismiss the suit, remand the case for reconsideration to lower court, stay the suit instead, or do all of the above. All right, remanding is what Shaktija thinks is the correct answer. That is correct. Excellent work. We see that the amendment, I told you the 1976 Act changed quite a few things up. It also inserted Rule 23A in Order XLI, and it made it explicit that even where the suit has been disposed of otherwise than on a preliminary point, and of course also including on a preliminary point, the appellate court shall have the power of remand if a retrial is considered necessary. So, remand the case for reconsideration to the lower court is the correct answer. When a suit is dismissed under Rule 2 or Rule 3 of Order 9 of the CPC, what is the remedy the plaintiff will have? Again, a consequences based question. Only remedy with the plaintiff is to seek setting aside of such order, or the plaintiff is debarred from filing a fresh suit, or the only remedy is to bring a fresh suit instead, or the plaintiff may, subject to the law of limitation, bring fresh suit, or he may apply for an order to set aside the dismissal. What is the correct option here? What is the remedy that CPC provides to the plaintiff? I have begun your timer. Come on, we need to pace up the answering. We have many questions to answer in the question paper. The correct answer is the plaintiff may, subject to the law of limitation, bring a fresh suit, or he may apply for an order to set aside the dismissal. Order 9, Rule 4 provides for this. Aditya, you are correct. Which of the following shall not be liable to sale or attachment for execution? Bills of exchange, necessary wearing apparel, banknotes, or promissory notes. So, not liable to attachment or sale for execution. Chetan thinks necessary wearing apparel, and that is correct. Section 60 in CPC explains this and says that necessary wearing apparel, cooking vessels, beds, bedding of judgment debtor, the wife and children, these belongings of the wife and children, personal ornaments which are of religious usage, they cannot be parted with. So they won't be attachable. The maxim actus curiae neminem gravabit relates to which of the following provisions of CPC? Section 141 or Section 148A or Section 152 or Rule 20 or Rule 1 Order 23. What do you guys think? It is Section 152. It finds its application in 152 of CPC. It states that if there is an error due to the negligence on behalf of the court itself, it must be rectified by the court itself. So, actus curiae neminem gravabit. If the court makes an error, it must fix it itself. Where any period is fixed or granted by the court for doing an act prescribed by the CPC, the court may enlarge such period by virtue of the following periods. So, what is the general extension period allowed to the courts under CPC? Is it not exceeding 90 days in total, not exceeding 30 days in total, not exceeding 60 days in total, or not exceeding 120 days in total. So, what is the cap on the extension that the courts can give for civil procedures generally? I have begun your timer. It is not exceeding 30 days in total. Aditya, that is correct. Option 2. As per section 148, so where the court is otherwise, where the civil procedure code is otherwise giving you a time limit, the court has a discretion to enlarge the period, but that whole discretion is capped at 30 days in total, not 60 Shakteja, only 30 days in total. All right, so we have 59. After the 60th question, we'll take a brief break, just a few minutes to refresh our minds a bit, take a sip of water, and come back refreshed for the remainder of 40 questions. So, this is question 59. The provisions of which sections of CPC shall apply to all persons arrested under CPC? Is it section 55, section 57, section 59, or all of the above? So, which section applies to all the arrests made, all the persons arrested under CPC? It is all of the above. So, 134 of CPC states that the provisions of sections 55, 57, and 59 shall, so far as may be, apply to all persons arrested under this code. Question 60, after which we will take a much needed break. A claims a sum of money as due to him from X or Y, and in a suit against both obtains a decree against X only. X appeals and A and Y are respondents. The appellate court has the power to do which of the following? The appellate court may decide in favor of X, or the appellate court does not have the power to pass a decree against Y, or is it both 1 and 2 are correct, or neither 1 is correct nor 2 is correct? What is the correct option here? Here, A has claimed a sum of money as due to him from X or Y, and he has a suit against both, but he is only able to obtain a decree against X. X is now appealing the decree and holding both A and Y as his respondents. What will the appellate court do? Decide in favor of X? Or does the appellate court not have the power to decide against Y? I'll start your timer now. Seems like a complex question, is not excessively complex. The court may decide in favor of X, right? So it has a power to pass decree in favor of X, and it also has a power to pass decree against Y. So option 2 itself was incorrect too. Shaktija, no, option 2 was incorrect too. The court, nothing is barring the court from deciding against Y either. So option 1 is correct. The court may decide in favor of X. That was the only appropriate option. We go to order XLI rule 33 for this. So, guys, we'll take a small break before moving on to question number 61. And you can tell me about how the preparations are going so far, and if you're facing any problems, and how you're feeling generally with the level of excitement and confidence for your upcoming MP prelims. All right, guys, just take this moment to take a sip of water and tell me about how the mocks are going and how, especially, the quiz session right now is going. All right, Atidivya, Shaktija, Chetan. Vijay, Sundeep. Sundeep also clocked in for a few answers, but not for all of them. I'm hoping you're taking notes on any questions you're getting wrong and then checking them later on. As always, you're welcome to discuss them with me. You have my contact on WhatsApp from your MP prelims group for the external students, and as always, for the internal students, they have my contact. All right, are we ready to move on to question 61 then? Okay. Well done, Aditya. Yes, I do see that you're very consistent and just keep on with the same spirit and with the same discipline, and you'll see and taste success soon. Don't worry. Just make sure you're putting in all the effort because, as I always say, if you're not putting in all the effort, some other student out there definitely is, and that is the person who will surpass you in the prelims results. So we don't want that. All right, moving on to question 61. Who can appoint a person to prosecute or defend any suit on behalf of a foreign ruler? Is it the central government, the state government, the presiding officer of High Court, or the Chief Justice of High Court? So, who can appoint a person to prosecute or defend any suit on behalf of a foreign ruler? This is also special power under CPC. All right, Shaksida thinks it's central government. Central government as well. That is correct. Section 85 is the relevant section for this. Next question. Can a decree be reversed due to error affecting merits of the case? Yes or no, or yes only after approval from the High Court, or yes only after approval from the central government? I'll start the timer now. The correct answer is just a simple yes, right? So, yeah. So, if it is about affecting merits, then it is allowed. Section 99 states that no decree is reversed or modified for error or irregularity not affecting merits of or jurisdiction, right? So again, at the way, it's not affecting. The section states it is not affecting. The question was asking if it is affecting. Again, purposeful reading is very important. See the question, I'm bringing up the slide again. Can a decree be reversed due to error affecting merits of that case? So if it is affecting jurisdiction, section 99, affecting jurisdiction, affecting merits, it can be reversed. All right? So Shaktija was correct. It is yes. Which of the following is not an appealable order under section 104? Is its order under section 35A, order made under section 35, order made under section 95, or all of the above? So per 104, which of these are not appealable? It's two orders under 35, right? 35 are not appealable. 35A, 95, they are appealable. It was asking us which is not appealable per 104. Per 104, 35A and 95, the other options are appealable. So 35 is not appealable. Which section allows exercise of powers of Advocate General outside of presidency towns? Is it Section 91, Section 92, Section 92A, Section 93? So, exercise of powers of Advocate General outside of presidency towns. It is 93. Correct option will be 4. It is 93. Under CPC as part of 5 Rule 16, it is not mandatory for the defendant to sign the copy of the summon. Mere acknowledgement is enough when delivered in person by a serving officer. State whether the statement is true or false. Is it you can choose 1, it's true, you can choose 2, it's false, you can choose 3, it is mandatory for the defendant to sign the copy of the summon, or you can choose 4, mere acknowledgement is enough when delivered in person by any official. So not just the serving officer, but any official. Shakteja thinks it's false. I've started the timer. Titave, what do you think? So that is correct. It is false. Shakteja was right, because Order 5 Rule 16 states that the serving officer delivering or tendering a copy of summons personally to a person or his agent, it will be still a requirement that he signs. We seek the signature of the person to whom it is delivered or tendered, so that we get an acknowledgement of the service endorsed on the original summons. So signature is, albeit necessary here. As per which provision of CPC is a suit to be set aside? Is a suit to set aside a decree on the ground of lack of territorial jurisdiction barred? So, as per which provision of CPC, again, which provision of CPC is a suit to set aside a decree on the ground of lack of territorial jurisdiction barred? What is barring the suit to set aside a decree on a ground of lack of territorial jurisdiction? What section deals with it? Section 21, Section 21A, Section 22, or Section number 37? I'll begin your timer shortly. Divya is correct. It is 21A. The general power to transfer suits under Section 24 of Code of Civil Procedure has been granted to which of the following? The High Court, the District Court, the Supreme Court, or both A and B? So both High and District Court. This is the power to transfer suits under 24 of CPC. I have started the timer. It is both 1 and 2. So we can see the case civil versus Bharat, transfer civil versus Bharat. The High Court held that it is a well settled principle that district judges and high court judges, they have the concurrent power jurisdiction to be able to make the transfers of cases under section number 24 of CPC, right? So, and that the proceedings for transfer can be instituted either simultaneously or separately before such cases. So both are empowered for making transfers. Which of the following courts may issue a precept? The concept of precepts is very known to us under CPC, but which court may issue it? Is it issuable by a district court, the High Court, or any court which is passing the decree, or the court in whose jurisdiction the property is situated? I will begin your timer. It is the court passing the decree that has this power. Section 46(1) provides for it. On which one of the following grounds under CPC may a warrant of arrest against a judgment debtor be cancelled by the court? On which of these following may the warrant of arrest against a judgment debtor be cancelled by the court? Is it the ground of serious illness? Is it the ground of appearing in marriage of son? Right? There is a marriage of the judgment debtor's son. Can that be a ground? Is it the ground that he had to cast a vote in a general election, or none of the above? Shaktija thinks it's serious illness. I've started the timer. Divya also thinks it's serious illness. That is correct. Section 59(1) provides that such warrants may be arrested if the ground found is serious illness. A claim made by the defendant in a suit against the plaintiff is called what? Again, a very basic concept-based question. Is it called a counterclaim, a cross suit, a cross action, or all of the above? All of the above the names for a claim made by the defendant in a suit against the plaintiff. It is called any of these. They are just synonyms. You can call it a counterclaim, right? A cross suit, a cross action, any of these. Generally, no attachment under a precept shall continue for more than how many months? More than 1 month, more than 2 months, 3 months, or 4 months. What is the general time for which no attachment under a precept shall continue? Hello Yash, nice to see you here in the session. I wonder why you were so late. We are nearing the final quarter of the session now. So it is 2, right? Section 46 provides that the precept it shall proceed, provides that the proviso states that provided that no attachment under a precept shall continue for more than 2 months, unless of course if it is extended by a court which ordered the decree, passed the decree. But generally, the precept is not allowed. No attachment clause is not allowed for a precept for any longer than 2 months. Which of the following suits is not a suit of civil nature? Yes, you have to keep up with the updates in the MP group. I sent out a message, and there were prompts earlier as well. So please be aware of all the developments on the group, please. Which of the following suits is not a suit of civil nature? A suit for specific relief, a suit for restitution of conjugal rights, a suit for recovery of voluntary payment and offerings, a suit to declare election of candidate contrary to law. So, which of these is not a suit of civil nature? I will begin your timer now. Let's try to get in the answers. Yash thinks it's a suit for recovery of voluntary payment and offerings. That is correct. Why? We look at the case of Shankar Shashi Devi Kulkarni versus Malhakar Kulkarni, and in it was stated that the suit for recovery of voluntary payment and offerings will not be counted towards a suit of civil nature because it is covering religious questions, and religious and social questions are not covered as civil questions to be considered in the court of law. Section 152 of CPC is based on which important principle? Is it that an act of a court shall not prejudice any party? Is it that it is the duty of the court that the records are true and that they represent correct state of affairs? Is it both 1 and 2, or is it none of the above? Let's be very particular in remembering what section 152 deals with. So which principle is it based upon? I will start the timer now. All right, Yash has answered option 1. It is actually both 1 and 2. Section 152 takes emphasis from 2 different principles. First, that an act of court should not prejudice any party. That is the maxim of actus curiae neminem gravabit. And 2, it is the duty of the court to see that the records are true and that they represent the correct state of affairs. And this was expressed in the case of Samarendra versus Krishna Kumar. So every court has an inherent power over its own records, so long as those records are within the court's power, and the court can set right any error that it has made within the case. So both 1 and 2 are the points of power for section 152. Next question. Doctrine of restitution is based on which of the following? Actus non facetium, actio personalis moritricum persona, actionable per se, or actus curiae neminem gravabit. What is the doctrine of restitution based on? I will begin your timer now. It is actually based on the maxim actus curiae eminem gravabit, right? That is correct. 4. Question 75. Second appeal shall not lie from any decree as provided under section 102 of CPC when the subject matter of original suit is for recovery of money not exceeding which of the following amounts? Is it rupees 10,000, rupees 50,000, rupees 25,000, or rupees 100,000? That is 1 lakh. What should be the correct option here? Yash thinks it's 25,000. I'm starting your timer. Come on, Aditya, Shakteja. It is 25,000. Aditya is correct. Section 102 provides for it. So, where the recovery is for no more than 25,000, no second appeal shall lie. The defendant is required to answer claim and file written statement within how long? Is it within 60 days of institution, 30 days of institution, 15 days of institution, or 90 days? Sorry, reception of the plaint. I will begin your timer. Yash thinks it's option 2, 30 days, and that is correct. We go to order 5, rule number 1 provides that within service of summons, 30 days of service of summons, the answer should be received. The written statement, that is the answer of the defendant, should be filed in the court. The relief granted in Order 39 is of which of the following natures? Is it an interim relief that the court grants? Is it a preventive relief? Is it both interim and preventive? Or is it none of the above? Order 39, the relief granted under Order 39. Both 1 and 2. It is both. It is both interim as well as preventive. So, yes, you are correct. Order 39 states that the court can make temporary injunctions in order to restrain acts, prevent certain acts, right? So, the nature is both. Which of the following combinations are not correctly matched? So, these are the combinations. Execution of decree is provided in section 77 of CPC. A letter of request is provided in Section 82 of CPC. Legal representative is referred to in Section 50 of CPC. Institution of suits is dealt with in Section 28 of CPC. The question is asking you which of the following combinations are not correctly matched. So, what will the correct option be? Will it be 1, 2, and 3, 1, 2, and 4, 1, 3, and 4, or 2, 3, and 4? I'll start the timer. 1, 2, and 4 says Atidivya and Yash. That is correct. Atidivya is correct. 1, 2, and 4 is right. Because execution of decree is actually under sections 37 through 39. Letter of request is dealt with under sections 75 through 78. And also in order 26 of CPC. And then institution of suits is dealt with under section 26 of CPC. Now, if two or more courts have jurisdiction to try a suit, it is open to the parties to select a particular forum, right? Such an agreement would be legal, valid, and enforceable. That is, agree to which court to go to. Which case held this, right? In which of the following cases was this thing held? Was this held in the case of Mathura Prasad versus Dosibai? Was this held in the case of Ram Kumar versus State of Haryana? Was this held in the case of Hakam Singh versus Gamao Limited? Was this held in the case of MS Hasnuddin versus State of Maharashtra? All right, let's have the rest of us answer as well. I'm not receiving all. Yes, Satadivya. Okay, so all of us answering 3. Hakam's case, Hakam Singh versus Gamon, that is correct. In this case, the court held. So, if two or more courts have jurisdiction, it is up to the selection of the parties to go to whichever court they want to. Such an agreement is legal, valid, and also enforceable. Next question. A person A, who's of little substance, erects a building which renders uninhabitable a family mansion belonging to B. A, in spite of his detention in prison and attachment of his property, declines to obey a decree obtained against him by B and directing him to remove the building. So A is not complying with anything. The court is of the opinion that no sum is realizable by the sale of A's property. No sum is realizable by the sale of A's property that would adequately compensate B for the depreciation in the value of his mansion. So, if this is a case before you tomorrow, how will you decide? How will you proceed? B may apply to the court to remove the building altogether. B may recover the cost of removal from A in the same execution proceedings. Will you allow for both 1 and 2 to happen? Or is it that B cannot apply to the court at all? Here, A is a person of little substance. He has created a building next to the family mansion of B, completely depreciating the value of B's mansion. And after that, A is in prison. He is not obeying any decrees. What will you, as a judge in this case, allow? All right, so Yash, tomorrow's Judge Yash is saying that B is allowed to apply to the court for the exact removal of A's building and also ask A for the cost of for covering the cost of the removal of the building. Shaktisha also appears to be doing so. So you have set a precedent. Let's see if this is being followed and if this is correct in law. Aditya, what would you do? Both Yash and Shakteja are right. Section 32 provides in its illustrations for such a situation. And here B is allowed to apply to the court for the removal of the building and also seek the recovery of the cost of removal from A, since A is in prison right now, of the removal of such a building that he has created. Section 18 of CPC provides for which of the following? Very simple question. Does it provide for institution of suit in respect of immovable property where the property is situated in the jurisdiction of one court? Does it provide for place of institution of suit in respect of immovable property where the property is situated in the jurisdiction of different courts? Does it create a provision for the place of institution of suits in respect of immovable property where the local limits of jurisdiction of court are uncertain? Or is it all of the above? All right, Yash, what do you think? Atidivya and Shakteja are correct. It deals with situations where the limits of jurisdictions of courts are uncertain. Section 18 provides for clarification on that point. Question 82. Magistrates have the power to remove public nuisance in certain circumstances by exercising which of the following kinds of powers? Is it their miscellaneous power, their established power, their summary power, or none of the above? Removal of public nuisance in certain circumstances. It is the summary power. Yash, you are right. Summary power is correct. So, next question. To compel attendance of a person to whom summon has been issued under Section 30 of CPC, the court can impose a fine up to which of these limits for compelling the attendance of a person under Section 30, where the summons have been served? Can the fine be up to 2,000, up to 4,000, up to 5,000, or up to 10,000 rupees? Aditya thinks it's 5,000. I have begun your timer. Let's try to get the answer in quickly. Aditya is correct. It's 5,000. Section number 32C is in order here, and that provides that imposition of a fine upon him not exceeding 5,000 rupees. Next, 84 states Section 56 of CPC explicitly prohibits the arrest of detention in civil prison in the execution of a decree of whom? Is it for sick people, for a woman, for children, or all of the above? The prohibition of detention in civil prison for the execution of decree. Atidevya thinks it's just women, so not sick people or children. It is women. That is correct. Section 56 provides for it. Notwithstanding anything in this part, the court shall not order the arrest or detention in the civil prison of a woman in execution of a decree for the payment of money. So, Shakteja, but there is a case related to payment of money, and there is a decree related to payment of money, and you want to compel the person to pay up the money. Women cannot be put in detention in civil prison. Men can, but women are exempted from this detention in civil prison. 85. The Rule Committee, as established under Section 123 of the CPC, shall consist of Option 1, 3 judges of the High Court, Option 2, 2 legal practitioners, Option 3, a judge of civil court, or Option 4, all of the above. It is 4, all of the above. Section 1232 deals with it and provides the composition of the committee. Atidevya and Yash, you're both correct. Under which of the following circumstances may review of judgment not lie? Important question. May review of judgment not lie? Where will review of judgment not lie? Is it by a decree or order from which an appeal is allowed by this court but where appeal has not been preferred? Is it by a decree or order from which no appeal is allowed by the CPC? Is it by a decision on a reference from a court of small causes? Or is it in a situation where appeal is dismissed? When will review of judgment not lie? I'll give you a little while before I start the timer. Alright, so it is when appeal is dismissed. Option number 4, Section 114 provides for it. Next question, 87. Which part of CPC deals with special provisions relating to the High Courts not being the court of a judicial commissioner? Is it part 2? Is it part 8? Is it part 9? Or is it part 1? It is part 9. Special provisions relating to the High Courts not being the court of a judicial commissioner. Which section of CPC deals with publication of rules? Is it Section 131, Section 132, Section 133, or Section 140? It is Section 131 that deals with publication of rules. Question 89. Essential condition provided under Section 101 of CPC for preferring second appeal is which of the following? Is it a substantial question of fact? Is it a substantial question of law? Is it an error regarding jurisdiction? Or is it a subject matter of public importance? Come on, let's have some guesses in the comments. It is a substantial question of law indeed. Section 101 provides for it. It's a substantial question of law. As it states, if the High Court is satisfied that the case involves a substantial question of law. Which section of CPC deals with exemption of other persons? These are the last 10 questions. Let's give it your all. Exemption of other persons is covered under which section? Section 130, Section 131, Section 133, or Section 140? It is section 133 that deals with exemption of other persons. Like we discussed a few questions earlier, we were discussing who is exempted, and 133 provides a list of exemptions. Question 91: who amongst the following may sue under section 92 of CPC? Who can sue? Is it the Advocate General and outside the presidency towns by the collector or by such an officer as the state government may appoint? Is it two or more persons having an interest in the trust? Is it neither option one nor option two, or is it both options one and two? It is actually both A and B. We go to section 92 that deals with public charities, and section 93 that deals with exercise of powers of Advocate General outside presidency towns. Question 92: appeals from original decrees shall not apply to appeals from which of the following? Appellate decrees, or orders under CPC, or orders under CRPC, or orders under special law. I have begun your timer. Let's try to give it extra speed in the final few questions. It is orders under CRPC, right? So, Section 108 states that appeals from original decrees shall, so far as may apply to appeals, as may be applied to appeals from appellate decrees. So, appellate decrees could not have been the correct answer there. Orders made under this court, CPC, so that could not have been the answer there. Orders made under special or local law, in which a different procedure is not provided, so it could not have been any other law. That only leaves CRPC. So, CRPC orders was the correct answer. Next question. In section 147, what happens if a person under disability gives consent to a proceeding with express leave of the court? 1. The same shall have effect as if person is not under disability. 2. The same shall have effect as if person has himself given consent. 3. Both 1 and 2. Or 4. None of the above. So a person under disability is giving consent with the express leave of the court. What is happening? Shaktisha thinks it will happen as if he has himself given consent. I've started your timer. Aditya thinks both, and that is correct. So both are assumed out of it. It will operate, right, as if it has been done by a person who is not disabled, and secondly, it has been done by a person who has himself given consent. So both can be made to be presumptions out of the act of a person who has made uh, uh, consent or agreement with the express leave of the court. 94. The general public can access the proceedings of a civil court. Which section provides for it to, right? Accessing the proceeding of a civil court by the general public. Is it section 153, section 153A, 153B, or is there no such provision in CPC and the statement stated right there is false? I'll start your timer. That's a very direct question. The correct answer here is 153B. Aditya, you are right. 153B states that the civil court is an open court. Public generally may have access to it. As many people as can be conveniently contained in a civil court, they can be held in there. So 153B, yes. 153B will be the correct answer. That was option 3. 95. Alien enemies may sue in court as if they were citizens of India with the permission of which of the following? With the permission of Chief Justice of Supreme Court, or is it the Chief Justice of High Court, or the President of India, or the central government itself? So whose permission would they have to seek? Aditya thinks central government. Yash as well. Shaktisha as well. Let's see what the correct answer is. It is indeed the central government. So aliens can sue with the permission of the central government. And again, we also discussed this ambit. They may sue in any court which is competent to try the case. 96, the last 4 questions. Come on, guys, let's give it a lot more speed now. The CPC provides that where any party aggrieved by a preliminary decree passed by after the commencement of this court does not appeal from such decree, he shall: Option 1, be precluded from disputing its correctness in any appeal which may be preferred from the final decree, or option 2, not be precluded from disputing its correctness in any appeal which may be preferred from the final decree, or option 3, either one or two depending on the facts of the case, or option 4, neither one nor two. I will start your timer. I'm expecting a lot more speed. Shaktisha thinks it's 1. And Shaktisha is correct. The correct legal stance is that the person will be precluded from disputing its correctness in an appeal which may be preferred from the final decree. That is right. Well done, Shaktisha. Well done, Aditya and Yash. Question 97. Which of the following is not a supplemental proceeding? 1. Grant of temporary injunction. 2. Appointment of receiver. 3. Appointment of executor. Or 4. Direction to defend in furnishing security. Direction to defendant to furnish security. Sorry. So, which is not a supplemental proceeding? Aditya thinks C, appointment of executor, and he is correct. Section 94 in point here. Appointment of executor is not a supplemental proceeding. Question number 98. Come on, we only have 3 questions. The last 3 questions up here. Within what time period may a respondent file cross objections from the day of service? Again, the time period is from the day of service of notice of the hearing of appeal as per Order 41 and Rule 22 of CPC. 45 days or 90 days or 1 month or 1 year. I have kickstarted the timer. It is 1 month indeed. Option 3 is correct. Well done, Shaktisha. Shaktisha is on a roll today. Excellent work. So, Order 41, Rule 22. 1 month is correct. 99. An interpleader suit is considered to be a dispute between the defendants, the plaintiffs, the petitioners, or the respondents. I've started the timer. It is the defendants. The defendants will have the interpleader suit amongst them. So Section 88 and Order 35 deal with this interpleader suits. The final question, the very final question, guys. Come on, Ayan. You can come in and answer as well. Please be encouraged. And as I know, Ayan and Yash, you went present for the commencement of this quiz session. It will be uploaded while the live session finishes. A few moments after that, you will be able to go back and also increase the playback speed or however it feels convenient, and you can go through all of the questions. So make sure you do that and you're not missing out on any of the questions discussed. So this is the final question. A, B, C, and D and E are enjoined jointly and severally liable for rupees 1,000 under a decree obtained by F. So a total of 6 people involved. Here A is obtaining a decree of rupees 100 against F singly and applying for execution to the court in which the joint decree is being executed. What happens in this case? 1. F may treat his joint decree as a cross decree under Order 21 Rule 18. Or 2, F cannot treat his joint decree as a cross decree under Order 21 Rule 18. Or 3, either 1 or 2. Or 4, none of the above. Alright, we think F may treat his decree as joint decree. Let's see what the correct option is. And that is right. We go to Order 21 Rule 18 and it is an illustration under there. The same illustration containing people A, B, C, D, E and decree obtained against F. Here F may treat his joint decree as cross decree under Rule 18 of Order 21. Well done, guys. Long-winded session. You did well. You performed very well. I hope the quiz was helpful, and I hope it helped you recapitulate all the concepts you have been tested for so far. Make sure you're taking the mocks. Make sure you're doing ample of revision at this time, and you're indicating your weak areas, especially, and working upon them. I hope you're doing that. That is a very important exercise to conduct at this point of time. Let me know how the session went in the comments, and I hope you go back to any section where you had a confusion, and you can freely reach out to me. You have my contact through WhatsApp on your MP preliminary series, mock test series WhatsApp group. You can contact me there. Have a great evening. Thank you for being part of this session, and all the best for your preparations. The exam is just about to happen. And if you have any confusion with respect to the mock test series, do let me know. As always, make sure you are taking the mock test series on the day of upload and not delaying it and taking it the second, third, and fourth day. Make sure you're doing it on time so that we can give you a ranking of how well you have prepared and how well you have scored as against the other students as well. So take care and a very good evening. We'll see you in the next few sessions as well. Thank you and goodbye.